The SEC ludicrous lawsuit against Ripple has enraged the Bitcoin community, as well as a countersuit in which the SEC will be put on trial. Will Ripple be successful in their lawsuit? Why is it taking so long for the matter to be resolved? Is Ripple capable of defeating the SEC in court? Let's see what happens. Let's help the Millionaire Mindset community flourish by liking and subscribing. 7 months into its legal battle, according to numerous experts, Ripple Labs faces an uphill battle with the Securities and Exchange Commission. Accusations that the government issued unregistered securities. Since the Securities and Exchange Commission (SEC) decided to file a prosecution against Ripple Labs for an alleged unregistered sale of cryptocurrency, a few attorneys have gained prominence online by implying that XRP is a security. One of the lawyers is Jeremy Hogan. His YouTube videos discuss and comment on a variety of topics. He has received a lot of publicity as a result of the lawsuit. Mr. Hogan offered to help. In his most recent, he answered any question in a conventional Ask Me Anything manner, while he answered to a wide range of questions and humor. Two in particular stood out. Is there a difference between Ripple selling XRP to Ripple selling XRP to Ripple selling XRP to Ripple selling XRP? Are corporations and Jed selling XRP from their taco stand wallets on open exchanges? Jed is a reference to Jed McCaleb, a co-founder of Ripple and the company's first CTO, who left the company to pursue other opportunities. Begin with Stellar. McCaleb continues to sell millions of XRP notwithstanding the ongoing SEC vs. The SEC contended that all XRP, including XRP sold on the secondary market, should be classified as when it sued Ripple, the securities were always unregistered. In a recent tweet, XRP holders attorney John Deaton responded to the topic. Even though the SEC claims that all XRP is unregistered securities, and that Brad is a fraudster, Garlinghouse and Chris Larsen have been unjustly rewarded, allowing Ripple co-founder Jed McCaleb to continue his work to sell his XRP for hundreds of millions of dollars in order to buy MoneyGram. Attorney Jeremy Hogan responded to the probe by claiming that Jed McCaleb was a liar. He was essentially selling XRP like Brad Garlinghouse and Chris Larsen because he wasn't employed. He wasn't even sued at the time by Ripple. Could he be? As a result, the legal question is Jed McCaleb an associate of Ripple? Asked Jeremy Hogan, and the short answer is that he is unlikely to benefit from Section 4 protections. After his breakup with Ripple as an executive, he got the rights to collect the tokens. As a result, Mr. McCaleb is presumably keeping a careful eye on the situation. Mr. Hogan stated, "I'm keeping a watch on the Ripple litigation and hoping that Ripple win." As the company's co-founder and chief technology officer, Jed McCaleb won 8 billion XRP coins from Ripple, which was later renamed Ripple Labs. McCaleb and Ripple came to an agreement that he would sell 1.5% of XRP daily volume every day. In 2020, McCaleb sold $400 million worth of XRP, bringing his total sales to almost $2.4 billion. This year's XRP values are expected to reach $1.95 billion, potentially worth $1.95 billion, despite the present dispute between the SEC and Ripple. As a result, crypto exchanges in the United States have delisted XRP. The SEC has made no public statement about Jed McCaleb's XRP activity, which has harmed them. At the time of writing, Ripple's native cryptocurrency, XRP, was trading between 662,133 cents and 676,781 cents. Vitness has said July 26, 2021 is the date for this video. On CoinMarketCap, the currency is now rated #6, having a market valuation of $30,668,892,712 and a 1.92% market share. Ripple just scored a key victory when the court ordered the deposition of former SEC Chairman Jay Clayton. William Hinman is the director. The case's novelty, as well as the huge public interest, are the unique circumstances that allow a high-ranking official to testify. The plaintiff's arguments were led by M.S. Stewart, a rookie attorney on the agent's. M.S. Stewart has to explain to the judge why the SEC claims privilege will be infringed if the deposition is scheduled to discuss a public statement based on William Hinman's personal views, not those of the Securities and Exchange Commission. Judge Sarah Nepern granted authorization for the deposition on Monday, July 26. The SEC stated that it would require further time to investigate. That can only mean one thing. The SEC intends to appeal the order authorizing them to do so. Unless the parties reach an agreement, the deposition will proceed, and it's almost never done. Attorney Jeremy Hogan said after the hearing in a video, "Will Ripple be able to locate it? I don't know the answer to that," Mr. Hogan said. However, "What I do know is that this battle is far from over." He adds, "We'll be presenting this case to the judge shortly." John Deaton, an attorney for XRP holders, reacted to the judge's judgment. With 11 core points that are covered by the privilege argument, a special master may, however, be required to rule on the potential stream of objections. It's now time to announce the lucky winner of our giveaway. Gilbert Farkas, Gilbert Farkas, Gilbert Farkas, Gilbert Farkas. Let's all congratulate Gilbert in the comments section below. XRP Army, let's return to the video now. The SEC case against Ripple is expected to be settled before trial. Pre-trial settlement agreements account for 96% of all SEC, 60% occur prior to litigation, and 90% occur before to discovery. Every new incident of the court battle between the two parties is closely followed by the whole industry, because it is expected to set a significant example for the crypto sector. The SEC and Ripple have teamed up. Attorney Jeremy Hogan recently expressed his thoughts on the far-reaching proposals made by, on the fair notice defense, Ripple wins. Now, based on his analysis, let's look at Mr. Hogan's opinions on what a settlement should look like. His knowledge of the Kik and Telegram cases, as well as his personal expertise resolving hundreds of instances, led him to this conclusion. To begin, he expects the SEC would seek language enjoining Ripple from doing so. More illegal transactions, as well as a civil penalty. Disgorgement should be difficult. XRP has changed hands thousands of times. To put it another way, there's no way to keep track of it, since there's no way to know who to disgorge to. Fairly disgorge earnings to investors. Later, Mr. Hogan highlighted Ripple's planned ambitions. It includes maintaining the company's operations and providing certainty for the future. Meanwhile, the SEC has asked the court to intervene, add 60 days to the deadlines for both fact and expert discovery. Defendants do not agree to the SEC findings. The financial watchdog says they are requesting this because they say that the SEC had enough of time to investigate the problem before filing litigation. Ripple expects to file a motion for summary judgment as soon as feasible. The parties have also filed a joint petition to extend the deadline, in addition to the SEC motion. Date for meeting and discussing on redactions and sealing of documents. To avoid burdening the court with superfluous arguments, specific materials will be held until June 9, 2021. Ripple, for its part, has requested that the SEC provide over internal material. Bitcoin, Ethereum, and XRP are all cryptocurrencies, despite the judge's best efforts. This action was prompted by the SEC refusal to release the records. It's worth mentioning that, for discovery violations, the judge might impose monetary penalties or even dismiss the case. The SEC has filed a lawsuit to compel Ripple to submit memorandums on XRP sales. The court denied Ripple's request to meet with the firm's attorneys a few days ago. Attorney-client privilege was allegedly violated. According to the labs, this was an important win for Ripple. In recent weeks, Ripple has had a string of successes. William Hinman's birthday is tomorrow. Deposition as former SEC Director of Corporation Finance, which has been a long time coming. The latest turn of events shows that Ripple has regained control of the situation. On the other hand, the Securities and Exchange Commission refuses to recognize this. A recent letter from the Department of Justice serves as a reminder to the court. The SEC was informed by the individuals filing that the above-mentioned public declaration had been made. This court is not bound by the SEC statement or any other binding. The SEC further noted that all courts that have heard this case have found in favor of Howey and his colleagues, that there is a plethora of case law interpreting and applying Howey all levels of the legal system, and the SEC relevant guidance provides all of the constitutionally needed notice. Individual defendants Brad Garlinghouse and Chris Larson wrote a letter in response to the lawsuit, contending that the SEC arguments only apply to the statements of the two SEC commissioners, serve to emphasize the agency's legal insufficiency, as well as the fact that the publicly condemned these two commissioners' considered views. The agency went. The SEC extraordinary public disclosure of its internal squabble merely adds fuel to the fire. Elucidate why the SEC accusations against the individual defendants must be dismissed by the court for allegedly assisting and abetting Ripple's violation of the Securities Act Section 5 on the Ripple case. The two SEC commissioners have thrown a bombshell. It comes at a good time for Ripple's lawyers, who will be questioned about it. On July 27, it hired ex-SEC Director William Hinman to boost its fair notice defense. Both parties have reached an agreement on how to handle Mr. Hinman's evidence. The SEC made a decision. On the majority of Ripple's inquiries, it's unclear what will happen at the deposition. The deadline for SEC Chairman Gary Gensler to respond to Senator Elizabeth Warren has passed. The following day, July 28, a holiday, she's curious about the SEC's ability to adequately regulate cryptocurrency exchanges, and to determine whether Congress needs to act to ensure that the SEC is able to do so, according to her request, has the appropriate jurisdiction to close current regulatory gaps. That letter also sparked a flurry of conjecture about what could be construed as a well-coordinated power attempt to circumvent the CFTC. Do you invest in XRP? And if you want to continue to know about XRP, we have got 2 more videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the following video, my friend. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content. The content in this video is for educational purposes only and hence should not be considered as financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.